Ms. Utterson of the Rutherford County Bar. I'm here for the appellant Ronald Mocny, the husband in this case. I'd like to reserve 4 minutes for rebuttal.
All right.
May it please the court. Your Honors, this is a divorce case with two parties who were either retired or near retirement at the time of the marriage. At the time of divorce, the parties were both in their late 70s, and so it's kind of different than most divorces that we deal with. No children and no long-term working in the future. The issue here is the inequitable division of the assets. These parties came into this case both relatively set for retirement. They married at a time the husband worked another year before he retired. He had a 401k, he had a pension. Wife owned a couple properties in Peru. She moved here from Peru to marry husband. The parties got married and they were in Pennsylvania at the time. They decided to move to Tennessee because wife didn't like the cold weather. That husband owned a house up in Pennsylvania, but they were trying to completely revamp it. Wasn't really in a livable condition, and it just kind of sat there. They moved to Tennessee, bought a home in Lawrenceburg. They then purchased another home in Spring Hill and used it as a rental property, income for the parties. And after 7 years of marriage, wife filed for divorce. Wife then reconciled and then resumed a divorce and then reconciled again and then resumed a divorce again right about the time that they had hit 10 years of marriage. Now, the circumstances here is that the parties initially started in a decent situation going into retirement. And now we're ending this case where husband has been ordered to pay to wife $125,000 plus. And in order to do that, he has to zero out his bank account and take out a mortgage on his home. Both parties have homes with no mortgages. Husband's is worth a little bit more than wife's. Now, for him to take out a mortgage, the minimum being $56,000 if he were to zero out his entire account, you're looking at a payment around $500 a month. Unknown if he can even qualify for a mortgage. And because he is on a fixed income, he is bringing in about $3,700 a month. That's a combination of his Social Security payment, which is about $2,000, his pension, which is about $1,300, and then his sales from hay, which he brings in about $2,000 a year. And from that, he pays his expenses, which leaves him with a little over about $550 a month. He was then ordered to pay $550 a month in alimony to the wife for 5 years, leaving him with nothing left over in his budget to pay for a mortgage. If he's paying a $500 mortgage, he's at about negative $500 a month, and he's got $0 in his savings account, and he's 78 years old. He's going to have to sell his house. He's going to have to move. It's not ideal. Obviously, it's never ideal after a divorce, but let's compare that to the circumstances of the wife.
Did the trial court value all of the property in this case?
Yes.
I mean, it appears that for instance, the wife's UECU account, the farm equipment, it's kind of hard to discern whether all of the personal property was even valued. In fact, there was even some language in the order saying hopefully the parties can sort out the remaining property, and if they can't, come back.
I think that was in regards to the personal property, the furniture, appliances, all of that, which was not an issue. Everybody agreed that they would split that, and that never became a problem. The issue, the major assets were all valued, and the most important one that we brought up is the wife's UECU account, because the court agreed the wife valued it as having about $146,100 in it at the time of trial. And the court decided that that was her separate property because she had sold one of her properties in Peru and the funds had gone into that account. However, she also had all of her Social Security income going into that account and her checks from the rental property in Spring Hill going into that account. So all of those funds were commingled, making that a marital asset in that account. But the trial court did not consider it a marital asset, and then also considered continuing it. Now, Your Honors, with
what about the farm equipment? Your client actually testified it was worth more than $10,000.
Right, and my client's testimony did change what he had originally estimated. You're correct, Your Honor. And that's why in our brief, I believe that based on what his testimony was, we listed it out as being worth something like $20,000. I believe the trial court gave it a higher value than that. If I can scroll up in my brief, I can tell you exactly what that number was. The trial court pulled out a couple of items from the farm equipment that they determined was husband's separate property, but did not value them specifically. So it made it kind of difficult to figure out what the court was valuing and how. But the court did put a value on the remainder of the farm equipment at $25,000. Wife's valuation of the farm equipment was, I believe initially was about $35,000. We kind of made a guesstimate at the remainder, as there were 2 items missing as separate property, and saying she valued the remainder at $31,800, and husband's initial valuation had been $10,000 for the entirety. The issue came as husband testified that it was very difficult to value the equipment. It was all very old, but it worked. So how do you value something that would be very costly to replace, but also is, some of them are 20, 30 years old. So what value are we looking at? Replacement value versus buying something new that is that old? It's hard to decipher that. And I think that for that reason, one of his listings from a couple years ago in tax filings that listed out his purchase prices, I believe that the trial court looked at those prices and picked something slightly
But he didn't
lower.
value the individual pieces?
No, he did not go through the individual pieces. It was a blanket, this is what we think we're going to put on the rest of the farm equipment. There was no value placed on the 2 that were separate property, and no specific value on each individual piece, and therefore I can't tell you if he misvalued any specific piece of equipment. I don't know. And of course that is part of the division of the marital estate, and the husband believes that they were valued too high because, yes, if we bought brand new, it's going to be very, very expensive. But his farm equipment is very old. And he's not running some kind of big commercial production farm. He's just haying a field and selling some hay to some local farmers. It's just a fun, hobby farm, something for him to do in his retirement. The income from it barely covers the cost of running the tractors, running the truck, all of those things. So it brings in a little bit extra. It's nice to have when you're on a fixed income, but it's by no means a money-making operation.
Tell me about the attorney's fees issue.
Okay, so the issue of the attorney's fees, Your Honor, is that the wife was granted attorney's fees, and the couple things. The attorney's fees paid by wife were considered in the division of the marital estate. It's one of the factors listed in 364121C, the attorney's fees paid by either party, and they considered, oh, well, she had to pay this much in attorney's fees, so maybe she should get more of the estate. But then later on, in alimony, husband was ordered to pay those attorney's fees as alimony and solito. And so that was kind of a double dipping. Wife got the benefit in the division of the marital assets of having paid those attorney's fees, but then she also got the benefit of having husband pay them for her. Further, there were just no findings as required by the Supreme Court rules regarding those fees. There was a single statement that they were reasonable and necessary.
What was the basis of the fees?
Honestly, Your Honor, I don't know, because there was no language in the final decree which gave a basis for the fees.
There was an affidavit that was
Right.
only referenced.
Yes, okay, so there was an affidavit, but it was filed. I did not see it because it was not filed until after this appeal was filed. It was filed more than 30 days after the final decree was filed. I assume it was sent, both myself and counsel at trial for the wife were requested to write up a proposed final decree. And then the trial court wrote their own final decree considering those proposals. I presume that that affidavit of attorney's fees was sent to the trial court judge with that proposed final decree of the wife.
Were you sent a copy?
But I was not provided a copy of that until it was filed with the court after this appeal was filed. So I never saw that affidavit. And after seeing it, it was completely insufficient. It did not cover the required requirements of Supreme Court Rule 8, Rules of Professional Responsibility 1.5. Just what they didn't cover them.
Was the amount in that affidavit the amount that the court awarded?
Yes, I believe so. It was the
exact
amount. And further, the award of legal fees is only appropriate when a spouse lacks sufficient funds to pay their own expenses or deplete their resources. There were no findings that wife lacked sufficient funds to pay them, and in fact, wife was granted her entire allegedly separate account of $146,100, from which she could pay that $20,000, and further, she had already paid it. It wasn't due and owing. There was no debt. So she'd already paid that from her account, so her account would have been higher if she hadn't paid it yet. She had the resources to pay those fees. She had already paid those fees, and there were just no findings made to support that order allotting her fees in this case. Thank you, members.
Thank you. You'll have your rebuttal time. Morning.
Good morning, Your Honors. May it please the Court, Will Holloway of the Williamson County Bar. I'm joined by Mr. Cameron Hoffmeyer of the Lawrence County Bar. Mr. Hoffmeyer represented the wife at trial.
Will you be handling the entire argument?
Yes, Your Honor.
Because I've got a list of 6 lawyers on here.
There's 2 of them back here. There's quite a few of them. They told me don't mess this up, so they're here to make sure I don't.
All right. Well, do a good job, then.
Thank you. Your Honor, husband elects to carve a wide path on this appeal. He challenges the classification of property, the valuation of property, the division of the property, and the alimony. And in doing so, alleges that the trial court abused its discretion in a variety of different ways. Wife's broad position on appeal is that the trial court should be affirmed in all respects, and that wife should be awarded her attorney's fees on the appeal. In making his argument on the appeal, many times husband creates a different case than what the trial court actually heard. For example, husband challenges the classification of what's been referred to as the Lawrenceburg home. And when he does so, he says the trial court abused his discretion because the trial court classified that home as marital property, and he should have classified it as separate property. Very briefly, if I could, just read to the court husband's actual closing argument in the trial, discussing marital property, volume 4, page 267 to 268, discussing the Lawrenceburg home. Now, is it marital? Question mark. I mean, probably. You know, I'm not going to stand up here and try to tell you it's not. As much as I don't want it to be, and my client doesn't want it to be, it was the marital residence. It is titled in both of their names. It's probably marital. So that was the position at trial, and now this issue is raised on appeal, and there's a few of those that are like that. For example, the alimony. Husband challenges the monthly amount of the alimony paid, awarded, and wife's position at trial was alimony in futuro. Husband's position was you shouldn't pay alimony. He shouldn't have to pay alimony, but if he does, the court should award 5 years transitional alimony of $500 a month. The trial court's actual award was 5 years transitional alimony, $550 a month. So husband argues that additional $50 a month constitutes an abuse of discretion from what his position was at trial. The argument that's made in the brief, the argument that's been made today with regards to I have to refinance, I have to draw out debt in order to pay this alimony, that wasn't presented to the trial court. That's not something the trial court ever had to consider. It's also not in line with the actual facts of the case. At the time of the trial, husband's Pennsylvania home, which was undisputed to be his separate property, was for sale. Husband valued it at $250,000. The trial court ultimately determined it was $298,000, but either way, it was unencumbered by any debt. There would certainly be enough proceeds from the sale, if husband so chose, that he could pay the alimony with it. It's $550 a month for 5 years. It's $33,000 total in alimony. So whatever the amount he received from the sale of the property, he could have paid his alimony with that. But again, neither of those arguments were made to the trial court. It's a new issue that's been brought on this appeal.
I want to ask you the same question I asked counsel for the appellant. Was all of the property adequately evaluated by the court?
I don't see how husband can, there wasn't any expert testimony as to the value of this property. Wife came into the court and said it was worth $31,800. Wife individually itemized each piece of this property. Husband came into court without any specific itemized list and said it's worth $10,000. Then, while testifying, husband said, you know what, it's actually worth more than that. That was one of the credibility problems that husband had in the case, and the trial court did go on to make some credibility findings against husband. What the trial court did is it took wife's list, and this is not spelled out in the order, but as you look at the record, it becomes clear. It took some of the items of personal property that wife classified as marital, and it classified them as separate, as husband's separate property. And so the value wasn't the $31,800 that wife specified. It was that new $25,000 and some change number, which is the value when you remove the separate property from the equation.
It didn't value the individual pieces of property on the farm equipment or anything of that nature?
Implicitly an adoption of wife's values, which the two competing positions it had were husband, who testified it was worth $10,000 as a whole, and then testified actually it's worth more than that, or wife, who specifically itemized. The court did the best with the evidence it had and specifically valued it that.
And what about the wife's UECU account?
UECU account. Undisputed that the vast majority of that account was funded with the sale of wife's Peru property. Undisputed that Peru property is was wife's separate property.
Was there other funds commingled in that account?
One source.
Marital funds?
There is not, our position is not marital funds, Your Honor. There is a reference in husband's brief to rental income being deposited in that account. There is a cite in husband's brief to that. The cite reference does not talk about rental income going into that account. So I'm not sure. I think that's just a mistake, but that's not discussed there. What did go into the account in addition to the Peru proceeds was wife's Social Security retirement. It was deposited in the account for a period of time, and that was clear in the record. Husband's position on appeal is that Social Security retirement benefits are marital property. Husband cites to 364121, which is the statute that defines marital property, and says that that statute talks about Social Security retirement benefits. It doesn't. It very clearly does not. What it discusses is Social Security disability payments. And it does that in the section that is talking about what I would classify as lost income. It talks about money you receive from personal injury awards for lost wages. It talks about workers' compensation awards. It talks about Social Security disability payments and says, following along the line of income earned during the marriage is marital property, these would also be marital property. There is a case, Brewer versus Brewer, out of this court, 2009. That case addressed SSI, which is supplemental security income. And that case very clearly said SSI is not marital property. Very clearly says.
What about rental income from the Spring Hill house? Did that go in there? No,
Your Honor. Our position, and we cite to our brief, is that there was a joint, same financial institution, a joint account that the money went into, but rental income did not go into wife's individual account. So the only combining, I won't use the term commingling just because it's a legal term, but the only combining of funds is the Peru property and the Social Security retirement benefits.
Let me ask you about the attorney's fees.
Yes, sir.
How did the court arrive at that number on the attorney's fees?
The number was...
Where did the number come from, first of all?
Right. The parties submitted proposed findings, facts, and conclusions of law at the conclusion of the case. And the parties, and this is in the transcript, and the court directed the parties to submit those to the court and then submit the affidavit for attorney's fees as well. And so that was done. The court then entered the final memorandum and order.
That affidavit was not filed until after the case went up on appeal, was it?
That's my understanding, Your Honor. Now,
So the court, in other words, that affidavit wasn't entered into evidence and it was not filed with the court, and was a copy sent to counsel?
yes, Your Honor. Now, this isn't in the record, but, it was represented that a copy was not received. My understanding is that a copy was sent to
Was there a
counsel.
certificate of service on it?
That's my understanding. I'm not sure. Let me clarify that. I'm not sure. But I do not believe, I understand Your Honor's point.
And was counsel given an opportunity to contest those fees?
There was no filing made, but counsel could have contested the fees if she chose to do so.
Well, she said she didn't even get a copy of the affidavit, and there was no hearing set to contest the fees.
Right.
And the judge apparently gave you the exact amount that was on that affidavit without it being put into evidence,
Well,
or the other side being given an opportunity to contest it.
this issue is not raised in the brief. It wasn't ever raised at the trial level. And so I do take Your Honor's point that it should have gone through the clerk's office to the court, but this is a new issue that's not hasn't been addressed because it just wasn't raised. Now, I do take Your Honor's point, and possibly the proper solution would be a remand for that process to be followed. I understand, but that's a new issue that we didn't address. The alimony argument that I understood was challenging the award of fees as being awarded as alimony in solito, not so much of the procedure with regards to the affidavit.
Well, I mean, the fact that it was awarded at all, apparently. I mean, if you say it was because it was awarded as alimony in solito, the fact that it was raised and awarded at all, since there was no ability to contest it.
There was a request for it at trial, and then the court instructed to submit the affidavit along with the proposed findings of facts and conclusions of law.
Are there sufficient findings in the trial court's order to justify an award of attorney fees?
There is not an analysis under Rule 8 of the Supreme Court rules. There is an analysis under 36-5-121 under the alimony factors, which is what the court did, is awarded the attorney's fees as alimony. And so there is an analysis under those factors and in the need and ability to pay analysis as well.
So there's no actual reference to the wife's inability to pay those fees and the husband having the necessary funds to pay those fees. Is there any reference to that at all in the order?
There is a reference to that in the broader context of alimony. Yes, Your Honor. There is an analysis with regards to need and ability to pay and an analysis of the factors of 36-5-121.
Well, when you look at the liquid assets that each party has or was awarded, how would the court justify ordering the husband to pay the $20,000 fee? The wife has a credit union account with approximately $150,000 in it. He has a credit union account where he's going to be left with 35, but then he's got to come up with another 70 to equalize the division. Under those facts, why would the wife get an award of attorney fees?
Husband has $300,000 of separate property as well. Wife's
Hasn't
hasn't sold, but it is a factor that can be considered with regards to the division of assets and also the payment of alimony. Wife's need was not challenged and is not challenged on this appeal, and was not met with regards to husband's ability to pay alimony. And so wife will be living a lifestyle that is dipping into her marital property, whereas husband will not have to. So neither of these parties were incredibly wealthy. I certainly can acknowledge that, but husband was certainly in an ability to pay it more than wife was.
Did the trial court reference where it derived that figure from in the final decree?
Of the
Attorney's fees?
the attorney's fees? He does not mention the affidavit, Your Honor. He references the analysis in the statute, but doesn't mention the the amount that was awarded.
And it doesn't say where it came from.
Right. And the technical answer to Your Honor's question is that the record just doesn't say. That's the very technical answer to your question. With regards to the analysis, if I could go back to one of your questions on the UECU checking account of wives, and that analysis as to whether this Social Security retirement is marital or separate property. It's cited in our brief, and we talked about Social Security retirement benefits and whether they can be considered marital property. This is not an issue I think a Tennessee court has specifically addressed. We cite to federal law that states that these benefits are not transferable or assignable at law or at equity, so they can't be assigned. No court has ever done that, so that's why we argue that it should be wife's separate property and no commingling occurred into that account. The last portion of my time, if I could, I'd like to just briefly discuss husband's challenges to the valuation of the property. Again, I feel that husband takes positions that are different than what he took to the trial court. No expert testified with regards to values of any real estate. The Lawrenceburg home, husband introduced Exhibit 13, which is his sworn asset and liability statement, indicating the home was worth $550,000. He confirmed in his testimony, again cited in wife's brief, that the home was worth $550,000. He now takes issue with that value. The Spring Hill home, he challenges, wife valued at $294,000, husband valued at $400,000. The court decided based on the testimony that it was worth $350,000 within the range of comparable values presented to the court. So our position is based on the evidence that was presented by the trial court, that it should be affirmed in all respects. We also ask for wife to be awarded attorney's fees on appeal.
Thank you.
Thank you.
You have 4 minutes.
Your Honors, I will just try to clarify a couple of the issues that were brought up here. The first one, the affidavit of attorney's fees. It was filed with the trial court on June 7th. It's in page 663 of the record. And the certificate of service on that notice of filing is June 7th of 2023. Our notice of appeal was filed on May 22nd of 2023. It was filed weeks after, and the certificate of service was weeks after the filing of this appeal. So no, there was definitely no opportunity for that affidavit to be attacked by myself or any other attorney Mr. Mocny might hire. And for that reason alone, I think the attorney's fees award is inappropriate, but amongst the other various reasons that we brought up in our brief. Now, Your Honor, yes, at closing, husband's position was there should not be an alimony award, but suggested that if an alimony award is found to be appropriate by the court, that it shouldn't be the $1,600 that wife was asking for. It shouldn't be more than $500. And then $550 was ordered. That does not in any way suggest that husband was agreeing to a $500 alimony award or a $550 alimony award, simply that a $1,600 alimony award would be absolutely ridiculous because it would reduce husband to having less income per month than wife had. And that simply is not applicable because husband at the time did not know the remainder of the ruling. He did not know that the court was going to rule that wife's UECU account was hers alone and not marital. He didn't know the court was going to rule that he was going to pay to wife half of his UECU account. He didn't know the court was going to order him to pay an additional $70,000 in an equalization payment or pay wife's attorney's fees.
What money went into that account? The wife's account?
The wife's account, her sale of the Peru house, her Social Security income, which there was a typo in my brief, yes, but that typo was just leaving out the letter B. It was 364121 B2A, which is the definition of marital property, and under B2B, actually, it lists retirement income. This is Social Security retirement and is drawn on the husband's account. It's income, and that counts as exact same as husband's retirement income. It is income for purposes of marital assets. It's not SSI, SSDI, which I don't know why it was suggested that husband interchangeably use those SSI and SSDI because they were actually never mentioned by husband. Wife doesn't receive SSI. She receives Social Security drawn on husband's account based on her marriage to him.
Was there any testimony that rental income also went into that account?
Your Honor, there was attempted testimony. Wife evaded that question. If you read the 3 pages referenced in my brief, I believe it's 87 through 89 of the transcript, wife has asked that question. She confirms, yes, there were checks sent after the joint accounts were closed, that half of it was sent to her. That being her account, her only account, while she refused to actually answer the question directly, that is where the checks went. There's no other place for them to have gone, in addition to her retirement checks. But reading through that, she avoids that question by answering every question with a question. She simply just doesn't answer it. And somehow we ended up moving on from that. But that is very, very clear that she received half of that money after the joint accounts were closed, because the joint accounts were closed in 2018. They were receiving rental income all the way through shortly before trial. So to suggest that she didn't receive rental income except that went into the joint account was just blatantly not true, and she admitted that in her testimony.
Thank you.
Thank you,
Let me
Your Honor.
ask you, did you attempt to establish, in regard to that credit union account, what amount of money was an accumulation of Social Security benefits that went into that account?
We did not know, because we did not know when the wife switched her Social Security from going into the joint account to going into her private account, and we did not know the amount that went in from the Peru sale. That was never provided. So that was not information that was ever suggested. She had a Peru sale in, I believe, 2015, and that amount was about $160,000 was put into the joint account, and eventually some 6 or 7 months later used partially to buy the Spring Hill house. But then she sold another apartment from Peru at some point and apparently put it into that account for some unknown amount. Her Social Security, presumably, the joint accounts were closed, I believe, end of 2018. She was receiving approximately $1,000 a month. So from 2018 all the way until time of trial in 2023, $1,000 a month approximately would have been going into that account with her Social Security.
Was there any testimony that there was any other account?
No. She had one account in Peru that had some $140 in it, but it was a Peru bank account.
So there was no other account other than that account?
No, no other account.
All right, so no proof to establish the amount of the accumulation of Social Security in that account?
No.
Because the accumulation of Social Security during a marriage would be a marital asset.
Right.
But that's all. I mean, the income that you get isn't really marital income necessarily, but it's accumulation of
Right.
it would be.
Well, and especially since during the remainder of the marriage, from filing of the divorce all the way through to reside together, and husband continued to pay all of the marital expenses through that entire time frame, which both parties did testify to. And so wife had no expenses aside from whatever personal needs she may want to spend her money on. So she's simply just accumulating money while the husband is supporting both of them throughout the entire marriage. And all the way up to, and at the time of trial, they were living in the same home, all the way waiting through for the order.
All right, thank you, Tom.
Thank you, Your Honors.
Thank you. Thank you for your argument. We'll take the matter under advisement and render an opinion as soon as possible. Thank you. May recess until the afternoon docket.